voice, but you can still hear me. All right. I'm going to start with some basics here. I mean, sometimes there are folks who are not just getting sworn in, that, you know, have been sworn into Virginia for some time. Everybody here, somebody just got sworn in or just getting sworn in this week? Is that right? Okay, good. Welcome to the Virginia Bar. I'm a member of two state bars myself, West Virginia and Virginia, and every state's got its own personality, if you will. Is anybody here a member of another state bar already? Okay, handful, so not all brand new to a person anyway. Anybody happen to be West Virginia? Because I have to apply for credit for this course in West Virginia, and if I'm going to do it, I might as well get credit at the same time. Okay, so if you give me your name and email address, I'll make sure that you have that when this is all done. See, there are all sorts of little tricks that they don't tell you about in law school. How many of you have jobs lined up, lawyer jobs lined up? And you're going to activate and weaponize that law degree. All right. All right. And how many of those are government jobs? All right. Very good. How many of you are in law firms, going to be going to private practice law firms? How many of those law firms have office managers? Law office managers full-time. All right. And then how many of those have more than 10 lawyers in those firms? Okay. How many of you have no idea what you're going to do with this law degree and law admission in the next couple of days? You guys are going to have the most fun over the next 5 years. Okay? I'm not kidding, and I'm not saying that to make you feel better or anything like that. You all are going to have the most fun with it. And while everybody else is burning out because they suddenly realize that they're this job that they work so hard for, and I'm speaking because I was one of these people. I was warned that I was one of them too. And they start going, oh, wait a minute, I'm not sure I love this much. You guys are going to be going, let me go find what I really like to do, and then I'll do it. Okay? But that's the beauty of being a lawyer, is you are never stuck. We think we are. You'll be around people who think they are. You are never stuck. We're professional learners. We're professional adapters. And if you don't like what you're doing today, you can be doing something else next week. So don't let anybody fool you into thinking something else. We're the ones who change the world anyway, so if nothing else, just go out and do that until you do decide what you really want to do. All right. Who am I? I'm from Winchester. As he said, I live in Berryville, but nobody knows where that is. So my law practice is in Winchester. We have about 10 people there. I get to be the managing attorney, which means if a phone call comes, it usually ends up on my voicemail. You had the good benefit of hearing Ned earlier. If you're lucky, you never have to hear from that office again. But if you're smart, you'll call that hotline when you have the I don't know what to do moments. They are great. And I can honestly tell you that more than once, either myself or someone sitting in my office has called or emailed them, and never once have we been disappointed with the response. It might not be the response we wanted, but it's always been a response that we could use, that we could work with, that was frankly quite compassionate, even when we may not have even felt like we deserved to be compassionate. So please use those resources, because your state parties are paying for them anyway, so avail yourself of them. I get to stand here and talk to you about charging and getting fees. This is not the most exciting thing you're going to hear about today, and it's not the most exciting thing that you get to do as a lawyer. But I will tell you, if you're in private practice and you're not doing this, you're not going to be in private practice for very long. So charging and getting fees are two separate things. There's charging, and then there's getting your fees. I'm going to talk about each of those separately as a result of that. I think the materials start on page 30 or so of your PDF, which I'm sure everybody is following along rapidly, having already reviewed it last night, right? So what does the name of this even mean? Charging your fees. The number one rule of charging a fee is it has to be reasonable. If you don't remember anything else about charging fees, remember that it has to be reasonable. And what you consider reasonable and what somebody else considers reasonable could be very different. There's no doubt about that. So what the heck does that even mean? Well, we do get some guidelines. They're in there under, let's see here, on page 30 under 1.801 of the materials. It's a good list for deciding whether something's reasonable or not. And I will tell you, I'm on one of the disciplinary committees that Ned talked about, and nary a month goes by that there isn't one of those give it for the grace of God moments that you have, and so many of them come back to really fee issues and fee disputes. The number one thing they put in there, these are not in any priority order, but I don't think it's an accident that number one is the time and labor required and the skill requisite to perform the legal service properly. This is why you start off with a low billable hour, and your senior partners and your former Supreme Court justices in retirement and things like that have perfectly outrageous billable hours, because the skill and experience requisite to the task is much higher. In theory, what they can do in a short time would take the rest of us much longer to do. That's the basic theory behind time and labor and the skill requisite. So you start low, you go up, but at the same time, the more experience you have in any given area, you're probably going to be able to increase what you would charge in every area that you might end up practicing in. Okay, number two, precluding other employment by the lawyer. You may be in a situation where, again, depending on the kind of practice you have or the size of the firm you're in, where some people spend all of their time with one client. That means that that one client, therefore, better be prepared to foot the bill not only for your salary and your support staff salary, but the relevant computer software and the overhead that has to be paid as well. Okay? What aren't you able to do because you're working on this case for this client? And that's something, again, the longer you're in practice, the more that's going to come, the more often that's going to come up. So, fees customarily charged in the locality for similar legal services. Notice that is just one of 8 things. There are no fee schedules in Virginia. There are no fee schedules, in fact, pretty much anywhere, because it would be an antitrust violation, if you remember that from law school. But customary in the area does, and it means geographic area, it also means legal area. Does that make sense? That is one of the factors that goes into it. The amount involved and the results obtained. That is a completely subjective standard, isn't it? The results obtained. You go, you know, when I do some judgment executions and stuff like that, I've had clients who are more than happy to pay me. I had one in particular who was happy to pay me $2,400 to collect a $2,000 judgment for them. They were perfectly happy with that. They considered that completely reasonable. I thought it was ridiculous. But it wasn't my standard to be judged. It was disclosed up front. They talked about it, and that's what they wanted to do, so that's what we did. You'll find that sometimes happens. On the other hand, you will have the ones that decide that taking any of your time at all. I actually had a case where another law firm hired my firm to pursue a bill against a client. Your insurance companies will tell you never to do that, of course. If you want to be the one that doesn't collect your bills, go ahead. They had hired me to collect this bill. If you've had some experience in criminal law in Virginia, I will tell you that with 3 felony charges against them in a jury trial in circuit court, the defense attorney, who was my client, had the matter dismissed on a motion to strike. Meaning they didn't even have to put on they didn't have to put on a defense. At the end of the Commonwealth's case, he makes the motion, case is dismissed. The judge says he didn't do any of it. In order to preserve your motion to strike in Virginia, you have to have not submitted any evidence. There are like all these rules that frankly I don't even know because I don't do criminal defense work. But in order to preserve that, he had to conduct that entire his defense representation during the case in chief in a certain way. Case gets dismissed. 2 years later, his client does not want to pay $1,500 because he didn't even call any witnesses. He took what had been scheduled as a 4-day jury trial and got rid of it after about 7 hours. And that was the entire dispute all the way through. So the amount involved and the results obtained. There it is. Time limitations imposed by the client or by the circumstances. That means a couple of things, such as it is initially comes across as, okay, if the client says, I want you to spend more than, you're billing me by the hour, don't spend more than 5 hours on it, you're pretty well stuck with that in a lot of ways. At the same time, when the client calls you at 5 o'clock on Wednesday evening and tells you that in the morning at 9 a.m. this, and this is happening and they need you there, you can charge more for that. I actually have a provision in my fee agreement that specifies if my staff has to work past regular 9 to 5 hours, or if anybody has to, because of lack of communication or late notice from the client, we get to charge double our rates. I have that in my fee agreement. I've been in private practice, self-employed, since 1998. I have never had to charge that fee more than once to any client. All of a sudden, they remember to call you early in the day, or even when they know the problem exists instead of when it's staring in the face. So that's issue number 5. Number 6, nature and length of the professional relationship with the client. That means your clients you've dealt with longer. It means they could have a higher rate, they might have a lower rate. That can go into it. Experience, reputation, and ability of the lawyer or lawyers performing the services. That's obviously when you've got more than one person, when you have people with great expertise to call them in, they'll probably end up with a higher rate than somebody who's a general practitioner. And whether the fee is fixed or contingent. That's the last one. Please note, contingency fees, they have to have an element of uncertainty to it. I'm assuming everybody knows what a contingency fee is. That's not necessarily fair. Contingency fee is I only get a fee paid, not costs and expenses. I only get my fee paid if I get something specific for the client, usually money. There has to be an element of uncertainty to it. Excuse me. And then, track your hours anyway, by the way, if you're doing contingency fee cases. Those are usually personal injury cases, collections cases. Like I said, we do a lot of judgment executions in my office where other attorneys got the underlying judgments, and we then track people down, find their stuff, and turn it into money. So we end up doing a lot of contingency fee cases. Going back to the reasonableness and the experience and expertise question, we always track our time on those cases anyway. So far so good. We've never had any issues, but that doesn't mean there won't be one when I get back to my office this afternoon that we need to deal with. And one of the things that anybody in the fee dispute program, the disciplinary office, my malpractice carrier, anybody's going to ask me is, how much time did you spend on this case? And we have to be able to show them that. So we always track our hours anyway on contingency fee cases. By the way, those are covered in 8.02 under there. All the elements and what that means to be a contingency fee case. And then fiduciaries under 1.803. There are also provisions about fiduciary compensation. It used to be, when I started practicing law, there was a percentage that like every fiduciary just automatically got 5 to 10% of whatever they were dealing with. That is no longer the case. There was something nobody expected. They called it the market crash, the housing crash. And then all of a sudden, those poor fiduciaries, all those trustees under deeds of trust, find that they don't always get 10% of the sales price. Sometimes they had to justify what they were earning on everything. Again, good idea to track your hours anyway, track what you were doing. I've never had somebody complain that I had a file that was just too well documented as far as what we did for people and when. The best way to avoid trouble is to have a written fee agreement. How many of you know that where you're going, there's a written fee agreement with every client for every case you're going to work on? How many of you know that? See? That's good. Most people don't know if they're going into another thing. I recommend that you do, because unfortunately, this is one of those things where if you're on the wrong side of something, it's still going to come down to being your responsibility, which is why it's part of this particular seminar. Even when it's not your responsibility inside that workplace, but ethically, as a lawyer, it is your responsibility to know what you're charging your client and that part of your attorney-client relationship. The best way to avoid trouble is to have a written fee agreement. The elements, again, in the materials on page 35 of a good written fee agreement. And I'm just going to talk, I'm going to ignore 2 through 6, which are also important, but they wouldn't be there. I'm going to tell you number 1 is the most important. What you are doing and what you are not doing. I, again, have yet to have somebody have a problem with what I was doing. It's what I am not doing. I would rather stick pencils in my eyes than do domestic relations work. Okay? I will wait tables before I do domestic relations work. I have worked with several attorneys, I've had several attorneys work for me that do domestic relations work. Good for them. And that always reaffirms, I am not the right lawyer for anyone's domestic relations case, anywhere. And therefore, when I have a client that I'm doing other things for, and they want me to hop in, and of course it always starts off, it's like having kids in a way, and it starts off with this little thing. Will you do this one little thing for me? And I've learned hard, but you stop it right there, because next thing you know, they just want you to sign on this pleading that they drafted, or whatever it might be. So I always have in my fee agreements what I am not doing, which includes the general statement of anything beyond that paragraph that says what I am doing. I stop everything litigation-wise. My whole firm, in fact, the fee agreement says we don't handle appeals beyond the circuit court level under this fee agreement. If there is one, and we're to be involved in it, we would need to have a separate fee agreement, because we know we are not experts on that. We may have done the underlying trial, and it's good for the client for us to be involved in an appeal, but they need somebody who knows how to do that specific thing of an appeal. Happy to work with them. We need a separate fee agreement, which then includes that we're working with this other attorney on it. So always have in there what you are not doing, as well as what you're doing, or all of a sudden you find yourself being general counsel on all matters, public and private, for whatever your client might be. And you don't know which client is going to be the problem client until it's too late, by the way. So, and along those lines, the most important advice I can give you on this, as this goes along, is to trust your gut. If you just don't feel right about this client and this representation, you need to trust that, and you need to decline representation. You can get more clients. There are so many clients out there looking for lawyers, no problem. You can find new clients. What you can't get is a new representation or a second chance. So, when in doubt, decline your representation, send them on to somebody else every time. Again, I've never regretted referring a client on. I have from time to time regretted taking a client on when I knew better, when I knew I just shouldn't. Something wasn't quite right. Clients who say the fee doesn't matter are more dangerous than those obsessed with nitpicking your bill. If somebody tells you money is, it's not the money, it's the principle of the thing, immediately double your fee estimate and double your fee advance. You know the difference between a fee advance and a retainer, by the way? But I got a couple of nods, that's good. Most lawyers don't. It does come up in disciplinary proceedings from time to time. A retainer is essentially a flat fee paid for a representative to be available to represent. Your fee advance is what somebody draws on, an advance payment of a fee that will be earned in the future. They have to be accounted for differently, or else you end up there with the state bar disciplinary committee. Double that as soon as somebody tells you that the money isn't important and it's not the money, it's the principle of the thing. Because you can always give it back if it turns out it was unnecessary or whatever. You give it back to them at the end. If it's not the money, that shouldn't be a problem. But that then gets to the next section, getting paid. So you've done all your work. How are you going to get the actual money in the door? Because believe it or not everybody will write you a check as soon as they get the bill. I know, it's hard to believe, but it's true. It happens all the time. And this applies no matter what kind of fee agreement you have, whether it's hourly, contingency, flat. There are lawyers out there who spend as much time working for free as they do working to get paid, and it's easier if you can cut it off on the front end. The best way to cut it off on the front end is to always bill regularly. This is your most important communication you will ever have with your client. They probably won't read everything else you send them. If you send them any letters that are more than a page, in front of one page, you can't really count on them reading it. Okay? They might. There are those that are very attentive to everything, but most of them mean to and just don't get to it. But those bills, they look at those very carefully. So if you bill regularly and give a detailed bill that informs them of what's going on and what you are asking to be paid for, you are far more likely to nip problems in the bud before they get out of control and have too many digits and commas in them. And you're more likely to get paid in a timely manner as a result. Always invite questions. Yes, ma'am?
Can you charge interest on bills if you have it in your fee agreement?
If you have it in a fee agreement in advance, yes. Signed fee agreement in advance. So, not that I would give you legal advice in a situation like this. I can tell you I have successfully enforced those provisions for lawyers. It also, the other advantage of that is it gives you something to compromise with. Most attorneys' billing is not based on some huge profit margin. I mean, it's got a profit margin, but it's not huge. So when you're in a negotiation with a client over paying a bill, it's very useful to have a provision for attorney's fees, a provision for interest, things like that. The client has to have the opportunity to consult with another attorney and review the contract before they sign it. But I've never had a problem enforcing that on the back end for the attorneys that I have represented. And like I said, most of the time we end up with a settlement that waives all of that, just because it gives that little extra room that they can afford to give something in order to settle a case and get me out of it and not have to pay me. I see another question over here. Yes, ma'am.
Yeah, just the regular bill. I mean, what if the client says, "Oh, it's cheaper," but at the end it's something that you just enforce and say, "You know, bring it to a regular bill," and
Yes, I actually recommend that myself. In addition to making sure you invite questions about the bill, because it's funny, Americans with our capitalist system, and we're really proud of it and everything, we don't really like talking about money. It sort of seems a little case. And clients will be afraid that if they question your bill, they'll insult you, and then you won't be as dedicated to their case. Okay, so you literally have to invite questions, especially with somebody that's not real experienced with having a lawyer. Insurance companies are more, they'll call you as soon as they get the bill in. What about this line and this point too, and that kind of stuff. Sophisticated clients. But you need to invite those questions, or else you might not get them until you're too late, and when things are bad. Always keep copies of them too, so you know what the heck they're talking about. You'd be surprised how many people don't keep copies of the bills that they send out to their clients. And if things are delinquent, you need to find out why. You need to call them and find out. You need to have an arrangement to continue the payment during the course of the representation. And if that is not happening, you need to find out why and take action. If it's something as simple as, well, they're going to pay you this much every month, please just get it in writing We're lawyers, just get it in writing. We are the cobbler's children when it comes to our business. We don't make our own shoes a lot of times. But be sure to get things like that in writing. I think, did Ned mention the fee dispute service for the state bar? There is one. If there's ever a dispute about fees, they do a really good job. In my opinion, I was involved in it one time. The matter got resolved within 2 weeks once the client, who had never asked me a single question about his bill, contacted the fee dispute center, filled out the form. I looked at it and was like, oh, well, here's what happened, and here's why that was on the bill, and here's what it is, but, how about I split it with you? I'll take off that. And he was thrilled. He thought that was great, and then he calls me for representation again, but, which obviously I didn't do. But your other option, if it's bad, you can terminate your representation. You can do that. You can do that in Virginia. As surely as the client can fire you anytime, you can fire your clients. What you can't do is prejudice your clients with the termination of your representation. That's where lawyers get into trouble when they fired their clients. And in fact, I'm a firm believer that you should go through your client list, and just the ones you just don't really like doing their work, the ones that you go, oh, not this again, whether they're good payers or not, life's too short, somebody else really wants that work. Find them the right lawyer for them anyway. But if you've got people that are delinquent, that you're concerned you're never going to get paid, look, if you're not going to get paid, why do you not get paid while you're sitting at home with your family? Why don't you just choose, instead of not getting paid, to sit at your office or in a courtroom or in an administrative hearing somewhere, choose to not get paid because you're doing something you wanted to do. Go ride your bike. Whatever. Choose when you're going to get paid and when you're not going to get paid. And it is okay to let go of a client for non-payment. People who are in criminal defense, what I learned when I was prosecuting is that there's like that's what's happened when the defense attorney, and I can't remember what it is now, but when the defense attorney is withdrawing from representation and his client now needs a public defender, there's like one of those phrases that we know that's what has happened, is the client just can't afford to pay the private defense attorney anymore. And off they go. And like I said, you can fire your client as long as you do it responsibly and in such a way that it doesn't prejudice. If you're involved in active litigation, I always recommend that you file a motion, that you get an agreed order from your client if possible, do whatever is necessary. Once or twice, I've seen situations where the judge did not allow the withdrawal of counsel until new counsel could be obtained. And that can be really tough to do in some situations, but at least then everybody's on notice that you're needing to get out and somebody else should be getting in there. There is a disengagement letter discussion, 1.808. Always disengage as well. Your malpractice carrier thanks me for reminding you of that, just like they thank me for reminding you of getting an engagement letter. Be sure to get a disengagement letter and send that out. Always, 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 always give the client back their file if they want it. Always. Always. I've never seen anybody get into trouble because they gave back the file. Even with their employers who want to charge a fee and want to do this and say don't give them your file until they pay the bill, ultimately it's their file. You can keep your own copy at your own expense, that's no problem. Give them back your file. A lot of lawyers get into trouble because they try to hold those files hostage. It's not your file. It's the client's work, the client, whether they paid for it or not. It is their legal work. They own it. Make sure that you give it to them. Okay? Did I answer your question adequately? Because yes, the answer is yes, you can. And I think really more lawyers should do it than do. But that's just because of what I do for a living. Yes, ma'am?
If you don't have hard copy files, do you have to give the client a hard copy file?
That is an excellent question that I have never actually heard a distinct answer to. If, when I get back to my office today, that question comes up, I would probably immediately email the ethics hotline, and I would burn this. I would burn a CD or whatever. I mean, what does that really say? That's actually easier than keeping a copy of a hard file for myself now. I have almost never, because my office is in the habit of copying everything to our clients. Again, I've never had, but so I've had one client ever complain that we just sent them too much information about their case. And that one client, what we did was we just saved all the information and sent it once a week instead of every day for their cases. We send them all of that, so most of the time they already have everything they need. Again, since 1998, I've had 2 times when clients have asked to have their files back at the end of representation. And one of those was my aunt, and it was her will that I had done. And she just said, you know what, give me the whole file, and if I need to come back and change something, I'll just bring you the file back. Great, super, one less thing for me to have in the attic. So, I don't really know. I don't think you could reasonably be required to go to that additional expense of printing it out, as long as you provide it to them in what, I will say, I have seen this problem, the proprietary software. Okay, I think if you provided it in a PDF though, I don't see how that could, really be an issue, as long as you provide them with their information in a format that they can use. That's your obligation, but always do it and always do it promptly. Good question. I'm going to think about that on the way home. Anything else? Any other questions? All right. Well, I think we're right at the time. Correct. Super. Very good. Well, have fun. I've got my cards. These are actually not my cards, my firm cards, because I didn't have my cards. But feel free, if you have questions later, to email me with them. And good luck. And again, welcome to Virginia. Thanks.
See, I didn't know you went to India. Oh, are you doing that? Yeah, okay. Well, that's prestigious, right? How's it going? Yeah, I was going to say, so, wait, so you, for example, people that are licensed in like New York, but they work in DC, they have to go to New York and see how they, like, are you planning to come back here after Draper, or you could be any? Oh, no, I'm coming back. Okay. So you have to be back to get sworn in anyway, right? Unless you found the sponsor and did all that stuff. Yeah, and I know like my school and all this stuff. I mean, it's probably not that hard, but it's still annoying. Yeah, did family come? Yeah, my family was there. I remember. Oh, okay. And then saying now, just in general.
But like I would have liked to have come over because once I go back there, I'm back to
Oh, okay. I think we signed a 12-month lease that started it. So if you're back next month, I don't know what'll happen. I'm doing one of those fellowships. A lot of people pick those things at Plan B places, but which is awkward because they're always wanting me to update them on what I've been doing to find some other kind of job. I'm like, hey, I actually just don't mind waiting around here. I mean, there's always a chance that everything actually did happen while I was there. I was favored for it, but the state commissioned their projects, the budget, just funded it. Once the person left, they gave the money to another office in a higher case. So it's not easy, but yeah, I'm not worried about it. DC, so I have a reverse review. Kind of fun. Yeah.
Oh, you're fine.
Yeah, what is that? Yoke? Did this come with that packet? Yeah, I know, but was that also in the original big pack? Because I feel like I already was. Isn't it like $20 to join the crew?
No, one of them is bigger. The other one, I think we have one of them. So it's 0. So that's what
I signed up for so much stuff. It may be another thing like this. Yeah. So, well, that's too late now. But was that this same? Was it Virginia Bar?
I think it was, but I think it was just in the section.
Yeah. Oh, okay. I'll have to get that.